the standard here, as I understand it, is it going to really substantially diminish competition? Explain to me why it could diminish competition, because right now, as I understand it, AT&T essentially does not compete with Time Warner.
That's correct. This is, in most cases, you're worried about two direct competitors getting together, like General Motors and Ford. But this is what is called a vertical case, as you say. And when you have a merger among competitors, it's fairly easy to see what kind of anti-competitive conduct could emerge. If those competitors have some enormous market share of a well-defined market, there can be danger in letting the total number of competitors in the market shrink from 6 to 5 or 5 to 4 or 3 to 2, although some people think that even with 2, like Coke and Pepsi or Visa, MasterCard or Boeing, Airbus, or United Launch Alliance, SpaceX, right, 2 is plenty. But anyway, that's what the debate is about. But in the vertical situation, it's much more difficult to define exactly what would be wrong with it. It used to be that the Supreme Court said, this is back in the 60s and early 70s, that what was wrong is that a vertical merger might change the trade patterns in a way that harms competition at either level. The classic example is an actual Supreme Court case from 1972 where the government succeeded in preventing Ford Motor Company from producing its own spark plugs by taking over Autolite Corporation, which was a supplier to Ford. And so the theory is that Ford no longer buys from Autolite's competitors, and Autolite no longer supplies Ford's competitors. But that's no longer regarded as a serious anti-competitive theory.
Well, let's pick up on exactly that. Let me turn to Jennifer Rhee here, because as I understand it, the government's case here is basically that AT&T will be able to charge more to its direct competitors for things like HBO and things like the Turner channels, CNN, and things like that. Why is that no longer a problem under competition law?
Well, it's not that it's no longer a problem under competition law. It's just economically, it's a much more complex theory of harm. To show that this strategy could actually be borne out by this merged company is difficult to do. You don't have this automatic example of added concentration in a market where it's thought if you take one competitor out, as the professor just explained, you know, it makes, obviously, prices can possibly go up. But here you have a situation where the government's going to have to show that it's going to economically, it's going to profit this merged company to either raise the price of its content or withhold its content, because it'll gain distributors by doing that. It'll gain subscribers by doing that, and ultimately it's going to net profitable.